Hey, everybody, it's me again. Okay, lots to share here. Good to be back. Welcome, Larry, and everybody else who's joining us right here at the second. So, big day today. Happy St. Patrick's Day. Just finished celebrating my birthday, which is tomorrow. My wife, a couple of my kids, well, at least the ones who were in town were here. We had a nice dinner. So, good to be here. What we're going to do this evening is, the focus is on additional mistakes living trust creators make. The reason I called it additional mistakes living trust creators make is because I did a live stream several weeks ago and talked about some of the mistakes that people who establish living trusts make. And I'll be flying through a quick summary of all those mistakes that I addressed several weeks ago in a separate live stream. But then there's more. So there's, anytime you have all these moving parts, you have, different, everybody's circumstance is unique. People have different kinds of assets, from real estate to stock to bank accounts to timeshares to businesses, LLCs, corporations, partnerships, lots of different types of assets, lots of different people involved in the creation of a living trust, the settlors, the beneficiaries, the trustees. We'll be talking through a lot of that. Oftentimes, there's lots of customization in these living trusts to apply for due to unique family circumstances. And then, every state has their own set of default rules that apply when something happens related to a trust and the trust instrument doesn't address it specifically. So there are rooms for there's a lot of room for error here. So let me run through the 7 or 8 mistakes and just fly through them so you don't have to go watch that previous video. I'll put a link to that video in the description once we finish here. But just so we'll all be up to speed, let me run through about 8 different mistakes people make, and then I'm going to spend a little more time on another 5 or 6 mistakes that people make when they create their living trust plan. Okay, so the ones I've already addressed, and I'll give a quick synopsis of those. One is people, and let me even back up further. So you're like, what's all this stuff about living trust? Why do people do it? What's the deal? Well, generally speaking, the traditional way to leave your estate to your survivors, to your loved ones, most people are aware of the concept of a will or last will and testament. You leave all of your assets in your name. You write your will, says when I pass away, I leave my estate to my 3 children equally, or however you'd want to customize the distribution of your estate. And then when you pass away, because you left all of the assets in your name, your assets are frozen. Your accounts, your stock, your business, nobody can transact it, other than perhaps IRAs and other assets where you've designated beneficiaries. But assets are frozen, and then your survivors have to typically deal with lawyers and go through a court and lawyer involved probate proceeding to get judges to validate that your will is valid, to get judges to sign court orders ordering that those assets that are in your name that are frozen, ordering banks, financial services companies, brokerage firms, ordering those third parties to transfer those assets to the appropriate heirs that are designated in the will. So that's what people talk about when they talk about having to go through probate. It's when you die with assets in your name, those assets are frozen. There's a court and attorney involved process that's designed to make sure the assets get distributed to the right people and all of the estate debts and other estate matters get handled properly. Now, some people, because in many circumstances that probate proceeding, it can be expensive. It involves lawyers. It involves proceedings at the courthouse that typically incur some delay, sometimes significant delay. Some people want to get around all that and avoid all of that court and lawyer involvement when they pass away, so they set up their living trust. Fred Flintstone sets up the Fred Flintstone Revocable Living Trust. He names himself as the trustee while he's alive. Trust says he can do whatever he wants to with all of the assets during his lifetime. There's no restrictions whatsoever. But in Fred's trust, Fred said, well, when I pass away, I designate Barney as the successor trustee, and I directed Barney or the trustee distribute my assets the following way. And then all those provisions that would have been in a will are now in a trust. So the idea here is things that are titled in the name of your trust when you pass away, they're not frozen. They don't go through a court and attorney involved process. The successor trustee that you name if they need to sell your house, for example. Really, the moment after you die, they can stick that for sale sign in your yard, go ahead and sell that house, transact other assets, distribute assets to the appropriate beneficiaries, all without that court and lawyer involvement. So these living trusts are very, very popular. And I'd say not only most, but an overwhelming majority of people who get their legal affairs in order with the desire to try to make things as easy as possible, and their survivors, they set up this, what I call living trust plan. I call it a living trust plan because there's more to it than just the living trust instrument. And we'll be talking about that here in the live stream. Quick hello to Jalen and Susie and everybody else from Illinois and California. Larry, of course, the idea behind the chat, love it. It gives us a little bit of community involvement. Feel free to post those contributions that you have, questions, comments, experiences. Post those kind of positive, constructive things in the chat. If you get negative or get a little silly or ugly, I'll ban you from the channel. I've only had to do that 2 or 3 times in the last 4 or 5 years. So we want to keep all that chat really, really good and really helpful to everybody involved. But I'll address all that chat stuff when I finish my presentation here, maybe 30 or 40 minutes from now. Okay, so let me touch on the previous mistakes that people make when they set up a living trust. And again, they're not intentionally making mistakes, and it's not even because people don't have the skill. It's just there's so many moving parts to dealing with an estate that sometimes things get overlooked, or they get, time goes by, or for one reason or another, things just, they get missed, and it has consequences typically on the back end. So the 8 or so that I addressed in the prior live stream, it's number one, the big one that you hear about when people say, well, what's the negatives of a living trust? Or what's some of the mistakes that people make when they create the living trust? The number one at the top of the list item, almost in every list of what happens when a living trust doesn't avoid probate, is that trust was not funded. I mentioned earlier, really 2 parts to setting up a trust to avoid probate. Yes, it's the creation of the trust, and which includes the customized trust instrument, but it also includes transferring those assets that are in your name that would have to go through probate if they're in your name when you pass away. Go ahead right now and transferring those assets to your trust during your lifetime. That's called funding your trust, transferring title of assets to your lifetime. So your home, your LLC membership interest, your corporate stock, all those things get titled from Fred Flintstone to Fred Flintstone as the trustee of the Fred Flintstone Living Trust, or something like that. So that's the key, and that's the mistake that people often make, either when they establish their trust, they don't retitle all of those assets that need to be titled, or they establish their trust and do transfer everything that needs to be titled and do fund their trust correctly. But then later in life, they acquire assets in their own name. They open up a new brokerage account. They acquire a new piece of land or piece of real estate, or they create an LLC in their name, and they neglected to open that account or purchase that property or start that business in the name of Fred Flintstone as trustee of the Fred Flintstone Trust. So when they die, there's still assets in their name, and that probate is necessary to transfer those assets that are in their name when they pass away to their living trust, pursuant to the pour over will, which I'll talk about in a moment. So that's the big mistake. Again, going through about 8 mistakes I covered in a previous live stream. Number 2 is some mistakes with trustee designations. People often create these trusts when they're 50 or when they're 55 or even they're 60. And, they don't even pass away until maybe they're in their 90s, decades after they set this up. So when you create your trust and when you make all of those trustee appointments and designations, you've got to cover not only for some of the contingencies, but what that trustee's rights and obligations are. So obvious, people should designate a trustee, should designate at least a backup or 2 or more. People should designate who can remove a trustee, who can replace a trustee, how does a new trustee get appointed, If the original trustee or successor trustee that was designated can't do it when you pass away. So there's a lot of pieces to the trustee designation that need to get right. Many people make the mistake and don't address that properly. Again, going through about 8 things that I addressed in a previous live stream. Some people over rely on the TOD, transfer or death, or POD designation. Now, some people use the TOD, transfer on death designation, to designate their trust as their TOD beneficiary. That's one way to do it. Some other people, as I mentioned in the previous live streams, make some false assumptions about living trusts. People make false assumptions that the trust is going to eliminate some taxes, or it's going to protect themselves from future creditors that they may have. And there's a number of different assumptions. Some people make the assumption that if they create their revocable living trust and transfer their assets to it, people make the false assumption that those assets now are not countable resources for long-term care, Medicaid eligibility. So a lot of people make false assumptions. Another mistake people make is failing to document the trust assets. Typically, when someone creates a trust, they don't designate all of the assets that are in the trust. They don't designate all of that in the trust instrument. They have a trust instrument that governs whatever is titled in the name of the trust. But it's really important that, when you pass away, your successor trustee have really immediate access to everything they need to do to get your trust settled, which is not only all of the legal documents, but an excellent inventory of assets and debts and other things that need to be administered by that successor trustee. So some people make the mistake of failing to document things properly. I mentioned sometimes, believe it or not, successor trustees can act too quickly after a settlor dies. Because they have immediate access, they can distribute trust assets to the beneficiary immediately after that trust settlor dies. And then lo and behold, the trustee finds out, there's $100,000 of debts that this person had that need to be paid. So now they're having to go back and ask the beneficiaries to return some of their inheritance. That can be awkward. Another big one from a tax perspective, very big, at least for the next couple of years, is failing to make what I call a portability election on a federal estate tax return after a married person dies. The big in a nutshell there is if a married person dies in 2024, they have a $13.61 million estate tax exemption. They're probably not going to use all of it because they probably don't have that much. So even though an estate tax return is not required to be filed after that first spouse dies, it can often save a lot of taxes down the road if there is an estate tax return filed within 9 months of the first spouse to die's death, so that the surviving spouse will be able to use the unused $13.61 million exemption amount of the first spouse to die. That's real important for the next couple of years, because in 2026, our estate tax exemption amount is scheduled to be cut in half, probably down to about $7 million and some change. Whereas now it's a much larger exemption. So if a spouse dies and they're not using a big chunk of their exemption, or maybe not using any of it, this estate tax return can be filed, portability election made, to really increase the estate tax exemption of the surviving spouse. So big deal there. Just if you have a spouse who dies this year or next year, or really any year after that, first thing you want to find out is, hey, will it help my beneficiaries down the road if I create, file, and make a portability election based on my spouse passing away? So that's another mistake people made, is they don't do that. And then I also mentioned in my previous live stream, sometimes it's a mistake that people create living trust and they fail to include that no contest clause. Particularly if you feel like there's going to be some animosity and resentment or some sibling rivalry after you pass away, or maybe somebody said, you know what, I'm not going to accept whatever you do, I'm going to contest it. So sometimes including that no contest clause, which generally says if anybody contests any of what I've done from an estate planning standpoint, they get nothing. So sometimes that can be a mistake by failing to include that no contest clause. Different states have different laws regarding the whether no contest clauses are permissible. Okay, so we got through that fast. That was the old list, the old live stream. Now there's even more mistakes. What do you know? So, in fact, somebody made a comment once, I think it was to my previous live stream. Well, all those mistakes must have been the attorney's fault. And yes, the attorney does bear some responsibility for getting some things right, but not all of these mistakes are as a result of an attorney's action or inaction. So it all depends on what the mistake is and kind of who's responsible for it, or who overlooked something, or who didn't address something. So, okay, now let's get into some more mistakes and a little bit more detail. The first one that I want to go over, maybe because it could be stated as the most important or most overlooked and could have the most damage type of mistake, is the when a married couple sets up their estate plan or their living trust plan, they don't fully address what will the surviving spouse's rights and duties be after the first spouse dies. Many married couples, when they set up their living trust, they're thinking all about their children. They're thinking, okay, after we both pass away, who am I going to appoint as the trustee? Am I going to offend any of my children if I appoint one child and I don't appoint the others? Or if I name one trustee or co-trustees, should I name a third party to be the successor trustee when I die? Should I name a corporate trustee? So it's most married couples, and at least I think their thought or their focus is what's going to happen to the kids when we both pass away. And I want to set things up so, it goes as smooth as possible, and it goes exactly how we want it to go. So a lot of effort and a lot of time and a lot of attention is given to what happens after both of us pass away for those married couples. But what often gets overlooked is what happens when the first spouse passes away. So there's lots of different options. I'm just going to focus on two for purposes of this live stream. So always tell people, I don't want to sound too salesy, but sometimes when I feel like I address what happens in my law firm, you can relate to it. Years ago, I started a national estate planning law firm. It's called America's Estate Planning Lawyers. There's links in the description for you to request meetings or talk about what your situation might be like. But always, when I have those conversations on Zoom with people, I'll always tell you, okay, I'll tell that married couple that I'm talking to, I'm like, let's start with this. Let's start with there's two ways that you can leave things to each other when one of you passes away. We'll get to the when both of you pass away here in a minute. But right now, let's focus on when one of you passes away. And while there are many different options, let's start with focusing on just two. So one option is, Fred and Wilma Flintstone. I may be speaking to both of them at the same time. When it's a married couple, I usually do. And I might say, Fred, let me knock you off first. And let's talk about how you might leave things to Wilma. I might say, Fred, one option, and Fred, you and Wilma, you guys have, $6 million of assets. Each of you has $3 million. So option one on this leaving things to your spouse is Fred has $3 million. Wilma has $3 million. Fred dies. Wilma still has her $3 million. Option one is Fred leaves his $3 million to Wilma. She owns it all. She controls it all. It's in a revocable trust for Wilma to do whatever she wants to with it for the rest of her lifetime. And then there's already going to be provisions in that trust for who gets those assets when Wilma later passes away. But when Fred leaves all of his assets to Wilma, the concern might be, as I speak bluntly to Fred and Wilma, and since I'm not talking to Fred and Wilma, I can be even more blunt in this live stream. So I could say, Fred, if you die first and you leave your $3 million to Wilma, and Wilma has the entire $6 million because she has her $3 million, and you just gave her your $3 million, she's got the whole $6 million. And you know what? She could either intentionally or sometimes unintentionally, she could completely exclude your child or your children. And if she does, that your children or your desired heirs or beneficiaries would get nothing. Not, they certainly won't get anything when you die because you left it all to Wilma, and Wilma could change the disposition of the entire 6 million after you die, Fred, and leave it to whoever she wants to. And again, in the back of their mind, they're, Fred's thinking, wow, Wilma, she's pretty. She has red hair or whatever it was in the Flintstones, and she had a nice trim figure. And so, the guys are at the rock factory or whatever it was, the quarry. They may be, trying to kind of come after Wilma. So Fred may say, I don't like that. On the other hand, Fred might say, I want to leave it all to Wilma because I know Wilma. She's a strong woman. She's independent. There is no way she would do anything to harm, our child or our children. And so there's some tax consequences to all of that as well. If Fred leaves everything to Wilma, again, Fred may have owned some appreciated assets, some stock, home, other assets. If Fred left everything to Wilma, where Fred left his $3 million to Wilma, now Wilma has the $6 million, and it's all $6 million, and whatever it grows to is included in Wilma's estate when Wilma later dies. Then when Fred dies, if Fred doesn't live in a community property state, then Fred's $3 million would get a step up in basis when Fred died, which is a good thing. All of that untaxed appreciation would permanently go untaxed. And then when Fred left it all to Wilma and it was all included in Wilma's estate, then, Wilma may have lived for many more years and it may have continued to grow. Then because Fred's $3 million was included in Wilma's estate, then all of what the $6 million turns into would get another step up in basis when Wilma later died. And that's a good thing. So that when Fred and Wilma's heirs inherit, if they sell things, they'll incur little or no capital gains tax because all of the assets received a step up in basis when Wilma later died. Now, yes, if Fred dies, he leaves everything to Wilma. He does make Wilma's estate large, but by Fred leaving everything to Wilma, he used the unlimited estate tax marital deduction. And so while his gross estate was $3 million, his estate got a $3 million deduction for leaving his estate to a spouse. So his gross estate was $3 million, his net estate was $0. It all got lumped into Wilma's estate, hence the portability election. Fred didn't use any of his $13.61 million estate tax exemption. Wilma or Fred's executor can file a IRS Form 706, elect that Fred's entire $13.61 million estate tax exemption be added to Wilma's estate tax exemption, whatever that might be when Wilma dies, depends on when she dies. So there's some real attractiveness to leaving everything, you could call it, to the survivor's trust, or making their joint trust completely revocable by the surviving spouse. There's some benefits to a married couple allowing that surviving spouse to control everything. The benefits are the double step up in basis. And oh, by the way, if Fred died, and if Fred and Wilma, when Fred died, lived in a community property state, all of the community property would get a step up in basis when Fred died, and then it would all get another step up in basis when Wilma died because it was all in Wilma's estate. So there's some benefits to that, but the main negative is there's no protection for Fred's heirs or children or child or beneficiaries after Fred dies, because it was all lumped into Wilma's estate and Wilma can leave it to whoever she wants to. So that's the downside of leaving everything to the surviving spouse. So the alternative I would tell Fred is, hey, Fred, if you pass away before Wilma, you've got $3 million. Wilma's got $3 million. When one of you dies, and Fred, let's say that's you, if you want to protect the future inheritance rights of your heirs, Fred, you can leave your $3 million in a trust, name someone as the trustee. Maybe you name Wilma. Maybe you name Wilma and an adult child as co-trustees. Maybe you name a corporate trustee. as that trustee. Maybe you say that Wilma gets the income from that trust for the rest of her lifetime. Maybe you say that the trustee or co-trustees can make distributions from that trust to Wilma, Fred, after you die out of the Fred trust for Wilma's maybe health, education, maintenance, and support. And then when Wilma later dies, whatever's left and what I'll call the Fred trust automatically reverts back to Fred's desired beneficiaries. And then Wilma's assets that she owns would go to her heirs. So that gives Fred's future heirs more protection than just leaving everything to Wilma. Does require a little bit more administrative paperwork when Fred dies. If there's the Fred and Wilma joint revocable living trust, and Fred wants this protection for his future heirs to receive what's left of Fred's assets when Wilma passes away down the road, then that joint trust is likely to say that when the first spouse dies, the assets get split. Fred's portion of the assets goes into the Fred trust, and Wilma's portion of the assets goes into the Wilma trust. The Fred trust, when Fred died, becomes irrevocable, but Wilma can change the Wilma trust. It's revocable. She can change it and change who gets that when she dies, but she can't change who gets the Fred trust when Wilma dies. So anyway, that's part of the married couples having to really dig deep into not only what happens after they both die, but what happens when one of them dies. And kind of, oh, by the way, this leaving things in trust for your spouse, it's not just for the blended families. I've made some remarks in prior live streams about the Brady Bunch family when Mike had 3 boys and Carol had 3 girls and they got married. And that's got leaving things in trust for your spouse written all over it, instead of just leaving everything to the surviving spouse. Because if Mike died and left his whole estate to Carol, she'd owned all of it. She'd probably leave it to her three daughters when she died. Mike's kids would be excluded. But Mike would probably say, no, when I pass away, I still want to provide for my wife, and I'm going to leave my assets to a trust. And under certain circumstances, distributions can be made that trust, from that trust to Carol. But when Carol dies, the Mike trust assets will go to Mike's 3 boys. But this whole leaving things in trust for your spouse, it's not exclusively a blended family situation at all. Many traditional one marriage with kids of the one marriage, they like the idea of when the first spouse dies, that spouse's assets go in trust, because I think a lot of couples some are worried that, after I die, my spouse may go wacko and leave it to people other than our children. But I think what starts to frustrate some married couples is this idea that when the first spouse dies, the surviving spouse could be influenced, maybe by a suitor, maybe by one of the children, or some other third party who may kind of talk that surviving spouse into doing something that, if both spouses were around, they probably wouldn't do. So I hear a lot of people tell me, Paul, I was involved in a situation where my uncle died, and, my aunt and uncle had 4 kids, and, my uncle died, and he left everything to my aunt. He didn't know any better. He wanted his wife to own everything. But then she got into a relationship, and she wound up leaving all of the assets to her next husband. And when she died, and then when her second husband dies, all of the assets went to her second husband's kids. So this leaving things in trust for your spouse, no way is it just a blended family situation. So the idea here is make an informed decision. Okay, so that's new mistake number 1, is failing to address the rights of the surviving spouse when the first spouse dies. New mistake number 2 that I want to talk about is, now we get to the children. Okay, now both spouses have passed away, but maybe that couple who set up that joint living trust, they didn't go in depth enough about how they were going to leave things to the children. And so there's some decisions there. Do you leave the assets, what I call outright, to the children, or do you leave assets in trust for the children? There's some lawyer advocates out there that say you should never leave assets outright to a child. I wouldn't go that far because, everybody's circumstance is so different. But the idea behind just my goal here, just make an informed decision. Be able to understand the pros and cons of the different options that you have and feel good about whatever decision you make. That's the thing about estate planning is there often is never a always do it this way or always do it that way. I think too many lawyers, make that assumption that, hey, you should never do this or you should always do this. And hey, every family's different. Every family's unique, but you do need to make a decision about whether to leave things outright to your children or leave it in trust for them. So some of the reasons people like the idea of leaving assets in a trust for their children is that divorce-proof concept. Yes, if you leave $1 million outright to your child, which means you just kind of dump it in their lap, from a future divorce-proof perspective, I don't know if I could say the word likely, but there's a chance that when your child inherits that $1 million, the moment they inherit it, it's theirs and theirs only. But if they mix up or commingle those assets with other assets that they have with their spouse, and then they get divorced, they may lose really up to half or more of the inheritance that you had left your child. So some parents like the concept of leaving assets in a trust for their child. So, for example, after Fred and Wilma Flintstone die, assets are left to the Pebbles Trust. And maybe Pebbles is the trustee, maybe she's not, but let's just say Pebbles is the trustee because Fred and Wilma don't want to put any restrictions on Pebbles. They just like it to be protected in case Pebbles gets divorced in the future. So Fred and Wilma leave their estate to the Pebbles Trust, or at least Pebbles' portion of the estate they leave to the Pebbles Trust. And all of that inheritance is titled in accounts, or the real estate Pebbles inheritance is entitled, Pebbles as trustee of the Pebbles Inheritance Trust. And so when parents leave assets to a trust for their child or for their children, it's less likely those inherited assets will get mixed up or commingled with other assets that child may have with their spouse. So if that child later gets divorced, the child keeps their trust, the child splits the other assets that the child acquired with their spouse, again, trying to make that inheritance divorce-proof. There may be other reasons to leave an inheritance for a child in a trust. Maybe your child has special needs and is getting certain government benefits, so then assets are left to a special needs trust. The idea there is if you leave assets to a child who is getting some form of a government benefit, their benefit will get reduced or eliminated if they inherit assets in their own name. So you can leave their inheritance to a special type of trust or special needs trust that's designed to supplement what the government gets them, and they don't lose any of their government benefits. Sometimes people are just financially immature and they're not ready to inherit $1 million or $100,000 or whatever the amount might be. So that way you might leave assets to a trust, name someone other than your child as the trustee to manage all of that, and then dictate in that trust under what circumstances will your child or that beneficiary be entitled to distributions from that trust. And then maybe a last point that I'll mention is some people, they want to kind of combine it all together. They want to combine the fact that they want to make it divorce proof. They may even want to make it kind of creditor proof for the child. And they don't want the child to have control until the child is more mature later in life. So one option is, Fred and Wilma pass away and Pebbles is 30 years old, but Pebbles is not demonstrating financial maturity. Fred and Wilma's living trust may say, after we both pass away, our estate will go to the Pebbles Trust, or a portion of our estate will go to the Pebbles Trust. If Pebbles is not yet, Fred and Wilma come up with an age, 50 years old. If Pebbles is not 50 when we pass away, then I don't want Pebbles to be the trustee of her own trust. I want it protected from her creditors. I don't want her being able to go blow it. So I'm going to name another trustee or co-trustee to be the trustee of the Pebbles Trust. And maybe Fred and Wilma are saying, she's got okay maturity. She's 30 now, but I don't want her dump it in her lap. So let me put in the Pebbles trust that when Pebble turns 50, then Pebbles can be the her own trustee of her trust. Let that trust last for the rest of Pebbles' lifetime, and so you'll get that divorce-proof protection. But enable that child of yours, that beneficiary of yours, to become their own trustee of their trust at a certain age or in certain intervals or at a certain time that another trustee may determine. So again, that's kind of combining many things together all at once. Okay. New mistake number 3, because our other live stream talked about all the other mistakes, is not preparing the trustees. Kind of related to a mistake I made earlier, but you and your spouse may create your living trust, and look, you have to make a conscious decision, and there's not a right or wrong here. Do you tell your future heirs, your beneficiaries, your trustees? Do you tell? Do you show? Do you demonstrate? Do you make them a part of the conversation so that they have good knowledge of what you've done? Or do you and your spouse just take care of all this stuff yourself, and you feel like, nope, I don't want them knowing anything now? I don't want them knowing how we're leaving our estate. I don't want them knowing who we designated as our successor trustee. I don't want them knowing the fair market value of everything that we have. I'd like to keep that close to the vest now. There's no right or wrong way to do it, but there is a right way to make that successor trustee's job easier when you, or if you're married, you and your spouse both pass away. So that's where you have to have things documented. That's where you have to communicate your wishes and your intentions about certain things. Again, with our law firm, we give every one of our clients a secure online vault account where they can document all of the assets, all of the debts. They can a copy of all of their trusts, their wills, their powers of attorney, their healthcare documents, their life insurance policies, their beneficiary designations. A copy of all of that can be uploaded to their secure online vault account. They can, if they want to, make that successor trustee a user on their account, or maybe they just leave the credentials so that user can find them when the parents pass away. So yes, preparing the successor trustee is making sure that when you pass away, that trustee has all of the information that they need to get what they need to get done. If they don't have access to all of the information, and they have to dig, and they have to find stuff later, and they have to go out to around to all of the banks in town and all of the brokerage firms in town, and they have to search in the land records to see whether you own some real estate or not, it's going to delay getting things settled by weeks, months, or years. And likely that frustration is going to happen as a result of that. So it's not only a combination of documenting, which is what our online vault does, not only just documenting what you have, but also leaving behind the information that should be left behind regarding how that successor trustee should exercise discretion that they may have the ability to exercise. So leaving behind things, okay, yes, you have a vacation property. Should the trustee sell that vacation property and then distribute the proceeds of the sale to the appropriate trust beneficiaries? Or would you prefer that trustee merely transfer the ownership of that vacation property to the trust beneficiaries so that the family continue owning it? What do you want the trustee to do with your home? What do you want the trustee to do with your business, your vehicles, your closely held or publicly traded stocks? Some parents say, well, I have an emotional attachment to this stock and I want to make sure it stays intact. I'd like each of my children to own shares in that stock. So that's the kind of information that you have to document, convey to your successor trustees. Plus, you may be designating that your successor trustee, after you and your spouse pass away, is the trustee of one or more living trust subtrusts. So, for example, you might say, well, I leave 60% of my estate to be divided among my 3 children, 20% each. But I have 8 grandchildren, and I'd like the remaining 40% of my estate to go in trusts for my grandchildren. My grandchildren are young. They range in age from 2 to 14. But that successor trustee will be the trustee over those sub-trusts for my grandchildren. Maybe in those sub-trusts for your grandchildren, you say that the trustee has the authority to make distributions to or for your grandchildren's health, education, maintenance, and support. Well, you really should communicate to your trustees, how would you like them to exercise their discretion when they are considering making a distribution to that grandchild after you pass away for their health, education, maintenance, and support? Would you want it to pay for their elementary school, their high school, their college, their trade school, community college, post-college expenses? Do you want it to pay for just tuition or living expenses? Or if they have a health need, under what circumstances? Or if they don't go to college, under what circumstances should that trustee exercise their discretion? So again, lots of information and lots of things you can do to adequately prepare your successor trustees so that things go exactly how you'd like them to go. All right, we've got 2 more. We've talked about 3. I call them new trust mistakes because they're not part of the original list of 8. But another one that's really important is people talk about getting a trust to avoid probate. Well, there's much more that people need than just a trust. And so this next new mistake is failing to incorporate both the last will and testament and that durable power of attorney as part of the living trust-based plan. Okay, so first let me talk about the power of attorney, and then I'll talk about the will as part of a living trust-based plan. Now, when someone sets up a living trust and they transfer their house to it and their business and their stock account, many cases their vehicles, their bank accounts, in the living trust that gets created, Fred Flintstone may say, or Fred and Wilma Flintstone may say, well, they will say, after we both pass away, I designate so-and-so as the successor trustee. So maybe they designate their adult child Pebbles, maybe their neighbor Barney, who knows. But they will designate when we die, who will be the trustee of this trust to make sure everything gets settled and the estate gets distributed to the appropriate beneficiaries that are listed in the trust. However, I mentioned really early in the live stream, one of the biggest concerns, or on the top of almost every list of what do you need to do when you create a living trust, or mistakes made when people create a living trust, is they don't fund their trust and they die with assets. I'm mixing up the power of attorney and the will. I told you I was going to talk about the power of attorney first. So in that Fred and Wilma trust, back to the power of attorney, in that Fred and Wilma trust, it not only says should not only say who's the trustee after Fred and Wilma die, but it also should say who's the trustee if Fred and Wilma, or if the survivor of them ever gets to a point in their lifetime where they're alive, but they're incapable of serving as the trustee. Maybe Fred dies and Wilma starts getting some dementia, or maybe she has a stroke, or maybe she just gets to a point, either because of illness or injury or mental incapacity, she's not able to handle her money. So your trust will have not only when you die, who's the trustee, but also when you're incapable, who's the trustee. And that trustee will be able to, once you've kind of met that trust requirement of incapacity, then that successor trustee can then kind of start taking over and managing the trust instruments, trust assets on your behalf. However, you likely have trust assets and you have assets still in your name, like maybe your traditional IRA, maybe your Roth IRA, maybe your life insurance policy that you own. And your successor trustee that you name in your trust, they typically only handle trust-related matters. So that's the incapacity planning for trust assets. But then you still need that durable power of attorney to handle all other matters that need to be handled while you're alive, but unable to transact for yourself. So if you can't transact your IRA, traditional, or Roth, or You can't make a life insurance decision about accessing cash value. Then you need that durable power of attorney, because if you don't have it, the consequences of not having it are you have an IRA. The IRA is only in your name. $25,000 of that IRA needs to be accessed to cover care that you need or living expenses that you have. But because you have no durable power of attorney, no one can access it. So then they've got to go through the court-involved guardianship proceeding where family members of yours will file a lawsuit against you, and as part of a long court proceeding, ask a judge to declare that you're incapable and incompetent, and ask a judge to appoint someone as your legal guardian. So the durable power of attorney eliminates the need for that guardianship proceeding, because in your durable power of attorney, you designate who you want to make it easy to be able to handle things for you while you're alive but incapable, or at least handle those non-trust assets. You're probably going to name the same person to be both the successor trustee and that be that agent on that durable power of attorney. So that's a key piece to the living trust plan. The other key piece is that will. I started talking about it earlier. Some people say, well, geez, if I have a living trust and that's designed to kind of replace my will, why do I need a will? Well, it's because some people who die with a living trust, their trust is not, as we said earlier, fully funded, and they still have assets in their name. There's this brokerage account that's still in their name. There's $100,000 of investments in stocks and bonds and mutual funds in that $100,000 brokerage account, and there's no TOD beneficiary. It's just in the individual's name. Well, that successor trustee is not going to have access to what is now a frozen brokerage account. And so whenever someone creates a trust, they also create a will. The slang term for it is a pour-over will, but it's a will. But we call it a pour-over will because the provisions of that will generally say that the practical effect of what it says is, if I die and I still have anything in my name, then I want that asset or those assets poured over into my trust. And the probate proceeding is required in order to get that asset transferred from the individual's name who died into their trust, so the successor trustee can then deal with it and transfer the assets to the appropriate trust beneficiaries. I'm going to make a little point here. I've never really seen it anywhere else. I've made it a couple of different times in some of my videos and on some of my live streams, though. Some of you may be saying, I don't want to create a living trust because I don't want to retitle what I have from my name into my trust name. And sometimes there's some merit for that. Sometimes it's they want to keep, they have some real estate interests that need to stay in their name, perhaps for a future financing purpose. The lender requires it be in their name. Or sometimes people just feel like, I don't want to do that paperwork. I don't want to transfer everything I have into my trust. So let's just leave it all in my name and let the will deal with it when I pass away. Well, I still feel like even if you don't want to fund a trust and you want to leave everything in your name, I still really like the idea of creating your living trust and having your pour over will. And if you do happen to leave everything in your name because you just want to, then when you pass away, yes, there's going to be a probate proceeding, but generally speaking, there's only going to be one participant, because that executor you name in your will is the same person as the successor trustee you name in your trust. And since all of the assets are being transferred from your estate to your trust, then that entire probate can be handled by one person. What makes probate difficult sometimes, every probate is different, is you've got a whole bunch of different people involved, and nobody understands what other people are doing. And everybody fears, I don't want to sign things because am I giving up rights? I don't understand any of this court paperwork. And people get frustrated, and that's what makes probates difficult, is because you got a lot of people involved in the court proceeding. And whenever whenever, they're involved in sharing a pot of money, it gets stressful and it's difficult. However, if you can create the one person probate, you have your living trust where you name a trustee, you have all the assets in your name, you have a will, names an executor, they're the same people. When you die, that one person is involved in that probate proceeding to transfer everything from your estate to your trust. Now the probate's behind everybody. And then that one trustee then can deal with the trust assets and distribute them perhaps to multiple beneficiaries without the court oversight that is that happens when several participants are involved in a probate. So just a quick thought there. All right, and then my last new mistake. I hope you go with me on the new mistake. Eight mistakes in the old video, 5 here. Last new mistake. See, this happen a lot. Is you create your living trust. You're all excited. You go see the lawyer. You're talking to the lawyer. You're talking about who's going to handle things when you pass away. You create all your powers of attorney. You transfer those assets that need to be in your trust to your trust. You've made some unique provisions about after you pass away, things go on in sub-trusts for your beneficiaries, and you feel like, boy, oh man, do I feel good now? I got my trust and everything's great. It's going to go exactly how I want it to go. I really like the way I set it up. And then lo and behold, you pass away 3 years later and you realize, or the survivors realized, hey, this person who just died, they own some IRAs that are not, they're not probate assets. And when they went through their estate planning creation process and created their will and their trust, now people are realizing the will and the trust have nothing to do with who gets this person's IRA. This person 30 years ago set up their IRA or established their 401k account. And when they set up the account, they designated beneficiaries. And those beneficiaries of the IRA that were designated 30 years ago, when whoever set up their IRA account, those beneficiaries are different than what this person did in their will or trust 3 years ago. And then you've got some major conflict because the will and the trust have no say-so as to where your non-probate IRA, traditional Roth life insurance goes, unless you name your estate or your trust as the beneficiary of those items. And there's some pros and cons there, particularly as it relates to required minimum distributions after a traditional IRA account owner dies. So my point there is the mistake that people make is they fail to address the non-trust assets when they create their trust. So you got to make sure all of that gets looked at and all of it gets addressed. Okay, so with that being said, let's run over. See what we've got in some chat. Got the always lovely hellos, especially from Larry. Larry, you're my backup. If I ever at the last minute can't make a presentation, you're it. You've been around enough. I feel like I've kind of taught you everything I know. So you're my backup. Just kidding, Larry. Susie, thanks. I hear some say to name. Yeah. All right. So yeah, Chuck says, thanks. I hear some attorneys say to name the living trust as a beneficiary, but unless you have minor, seems unneeded. So yeah, this is one of those, it depends things. So, if you have, you have a $1 million IRA, let's just say you're not married for now, divorced, or your spouse passed away. You've got 2 really mature, responsible adult children. Yeah, I like the idea of just naming the children individually as the perhaps 50-50 beneficiaries on the IRA and the life insurance. It's a lot simpler on everybody that's involved, the lawyers, the accountants, the financial institutions, the financial advisor, the beneficiaries. It's a lot easier on everybody when individuals are named as beneficiaries. Everybody's ears perk up and alarms kind of go off when somebody names a trust as a beneficiary. Oh, what does that mean? And now you've got to look through all the terms of the trust instrument. And so yeah, if we can allow people to make good informed decisions and name individuals as beneficiaries, Yeah, Chuck, just like you're saying, there are circumstances where trusts need to be named as beneficiaries. Minor children is one. The blended family situation might be another. The financially immature or special needs child is another. So it's on an individual basis, but I'm all for you, Chuck. Let's make things simple where we can. All right, good Charlie, the Charlie Gipple. Hey, no, I don't think I've seen that name before. Good to have you here, Charlie, CFP from Iowa. Fantastic. What if it's an irrevocable trust? So, I'd probably ask you, Judith, tell me more. What do you mean? What if it's an irrevocable trust? What question are you hoping I ask for? Lots of emojis going on there with Ms. G the alien. Boy, you got an alien in the name and you got some scary skulls there. Naomi, I already set up living with the state lawyer 3 years. Can I change my state lawyer to someone else? If so, do I have to pay the whole fee I paid to the first lawyer? Good question, Naomi. Another one of those questions where I got to answer, it depends. So the answer to your first question, can I change my estate lawyer to someone else? Absolutely. Once you have an estate lawyer, just like if you have any kind of service provider, you're not locked in for all of duration to use that person's services for the rest of your life. So pretty easy to answer that one. If so, do I have to pay the whole fee I paid to the first lawyer? That all depends on the conversation that you may have with the new lawyer. And so that is a tough one. Been involved many times where people came to me and they told me that they had done something recently. Recent might have been 6 months or a year or 2 years, or in your case, 3 years ago. But they're just not comfortable with it and they want to major changes or just kind of do a do-over. And so it frustrates me just as much as it frustrates them that that's a whole new kind of fee arrangement. So always would prefer to see you get it right on the front end, but the answer is it just depends on the conversation that you have with, I suppose, the second lawyer. Shane, good to see you. I'd like to see you welcoming everybody. Judith, can I make an appointment with you because I have not been advised appropriately? The way to do that, go look in the description to this YouTube video. There's a place for you to request a Zoom meeting with me, answer a few questions, and then if it's the right fit, we'll send you my calendar link and we're off and running. Good to see the thumbs up. I'm a big emoji fan, Susie. Good job. Yeah, you're in Georgia. So yeah, we handle clients all over the country and we do it. You work with me and my staff. If you're in Georgia, we have our Georgia co-counsel lawyers who participate in the process. So yeah, we can help people all over the country, and we have a process for doing that to make sure everything gets done right and in compliance with all the rules that we have to comply with. So, all right, does a pour-over will effectively transfer all assets to the trust that may have been otherwise overlooked and left out of the trust? Yeah, Larry, it does effectively transfer all of those otherwise overlooked asset sets, but you've got to go through the probate process to get it done. So yeah, that pour-over will just says whatever I own when I die that's not already in my trust, I want it poured over into my trust. So it really does cover all the overlooked assets. Those assets don't need to be itemized out in the will. So thanks, Larry. All right, we got Chelsea. Hey, good to have you, Chelsea. Let's see what happened to live chat. We should be on some live chat. From Jalen, Paul, can you speak to any issues being overinsured that may arise from life insurance companies? Does that mean you're asking about you have too much life insurance? I'm not even really sure what you're getting at. To speak to any issues of being overinsured. So not really sure what you're asking. I'd need to know more. Steve, you're welcome. Thanks to you for participating and chatting, just even if it's once or twice here. From private, never do business with Voya because they do not recognize and request. So yeah, something happened there. Can't speak to that. Institutional successor trustee. So good question there. Private says, would you recommend as an who would you recommend? So it's hard for me to feel good about a recommendation for a particular institutional or corporate successor trustee. I've worked with a bunch of them, and it seems like, you get to know somebody, one of the trust officers at a particular institution, and the next thing you know, they've moved to another corporate trust institution. So, it's tough for me to recommend one. Always kind of start with, hey, Mr. and Mrs. So-and-so, do you have a relationship with an existing large financial institution that may also have a trust company there? Maybe you could talk to their trust officers and just get a feel for what that might look like if you used your financial institution's, trust company. So, but I've worked with a bunch, and how much do they charge to administer the trust? Geez, everyone has their own fee schedule. Sometimes these fee schedules are online. I know on a previous live stream, just to pick one out in particular, I addressed how the Vanguard Trust Company fee schedule said it was something like, don't quote me to the penny, but for a $3 million trust, and there's a sliding scale for fees, but it was something like 0.55% per year for them to serve as that trustee to do both the administrative duties and handle the investment piece as well. So Vanguard's known for being a kind of a low-cost provider. It kind of typically goes up from there. Bam Bam isn't named. So is Bam Bam one of the children? Maybe so. Maybe that was Barney's. I don't remember. It's been a long time. TPP. Are there legal services where someone can upload scanned copies of their trust if they only have a hard copy? Not sure I would trust Dropbox to keep such documents. So, all I can tell you is what we do for our clients, which, I've always kind of searched out all the different options we have. It's not Dropbox, but it's an application written specifically for estate attorneys to keep everything private. And so we enable all of our clients to have an account. And then, all those hard copies of all the documents get uploaded to their online vault account. But yeah, it is a major issue. A lot of people out there, I'd say most, even here in 2024, most people, they just have the hard copy of what they signed years or decades ago. And so, maybe it was organized in some kind of binder like this. Maybe it was just stuffed in an envelope. And then, people move all the time. And heck, we had a hurricane in our area, and a lot of bank safe deposit boxes took on water, and people's documents were just never found again. And so it's a problem. So yeah, having that electronic, secure, safe, not going to go anywhere piece to me is kind of an important piece. All right. Good. I'm glad you got your will updated, AJ in Pennsylvania. Fantastic. Susie. Hey, good to see you, Susie. Jennifer with a little hand clap. Like to see it. Once someone gets dementia and you are both on each other's trust, can the person without dementia pick someone else for the whole family? Once someone gets dementia and you are both on. So maybe what you're getting at is you designated someone to be the successor trustee of your trust. Now they have dementia. So that's where I go back to the mistake that people make, is not making all those trustee designations. So let's say you die, you've got a successor trustee name, but they have dementia. So now we got to look to the trust instrument. Did you address, is there another second successor trustee, or under what circumstances can a trustee be removed? Because they have dementia, they need to be removed. And who can remove them? Can a majority of the beneficiaries remove a trustee? Can all of the beneficiaries or a specific named beneficiary remove a trustee? And then if they are removed, who can appoint a new trustee? So all that can get provided for and customized in the trust instrument. All right. After finally getting my will rewritten, do I need to let the old lawyer know? Well, there's no good question. There's no requirement that you let the old lawyer know. My suspicion is, in your new will, probably in the first sentence of your new will, if not the first paragraph. It probably says something like, I, AJ Tom, whatever your real name is, hereby revoke all of my prior wills and codicils. Codicil is like an amendment to a will. So by signing your new will, you automatically revoked your prior will, assuming it says that in your will, which it does in most wills. Most wills, it specifically and expressly says it's revoking prior wills. So then, number one, your old will that the other lawyer did is revoked. Should you contact them? Your call. I mean, I guess there could be some confusion if you pass away and the old lawyer thinks, that what that lawyer did is what's controlling, but then the new lawyer or the family could tell, no, lawyer, they revoked that will you did and they did a new one. So it's not required, and your call whether you'd want to. It may depend on the relationship you have with that prior attorney. All right, I want to try to get a Zoom meeting, Kizozu says, but I fell through the cracks. I will try to get it again. Fantastic. Link in the description. Bam Bam. I thought Susie Bam Bam was Barney and Betty's son, their neighbor. Yep, Bam Bam. And Pebbles was Fred and Wilma's daughter. All right. Faye says, my husband is 82. I'm 66. We only have $10,000. Well, should I put the policy? I can't lose the policies to Medicaid if he goes into a nursing home. So, yep, there's, you would have to look at the specific rules in your state on whether these low cash value life insurance policies are considered a countable resource. So 10,000 of whole life is kind of on the lower end, obviously. All right. And then, so it just depends on what the Medicaid rules are. And, probably if you're dealing with lawyers and setting up irrevocable trusts to try to protect a $10,000 whole life insurance, that's a tough one, because it sounds like the resources are limited when you say you can't lose the policies, but you'd have to spend the resources in order to do that, get that in place. All right. Bam Bam was adopted as he was left on their doorstep. Okay. This is some good Flintstones history. Thanks again, Larry. Thanks to you as well. So, okay. Another good one. So now we've covered originally 8 mistakes people make with living trust. We just added another 5. Again, I don't want you thinking, why would anybody even do something like this if there's the possibility for so many different mistakes to be made? But, these are just things to look out for. It's not that like these mistakes are made every time, but the more knowledge we can share, the more we can help people really leave that lasting legacy for their survivors in a good way. All right, we still got more, and let's see. I'm here, didn't miss anything. Thank goodness. Good, fantastic. And of course, the recording will be up on the YouTube channel momentarily. All right, y'all have a great evening. Take care. See you later.